Call the first case, please.
Matthew Long versus Chattanooga Fire and Police Pension Fund.
We'll hear from the appellant.
May it please the court, Robert Parsley with Miller & Martin and my colleague Jessica Walensky for the appellant, the Chattanooga City Fire and Police Pension Board. This is an appeal from denial of benefits.
Reserve any time for rebuttal?
Yeah, 4 minutes, Your Honor.
4 minutes, that'll be fine.
Thank you. The board denied benefits for solely emotional harm for a firefighter, and the Chancery Court reversed and granted full, permanent, total benefits for the firefighter. There's two very narrow issues that I think are pivotal today, and I'd like to focus argument on those two issues, of course, without waiving anything else that we may not get to. The first issue is a question of subject matter jurisdiction. Does this court, or the courts generally, have subject matter jurisdiction over this case? Our argument in our opening brief was no, and after reading opposing counsel's brief, we had to admit that they're right, and so our answer is now yes.
Always good to answer your own question.
Answer your own question. That's right. And then on the second, and I want to say just a few things about that. The second issue is the disability plan at issue requires that for a firefighter or police officer to recover benefits for solely emotional harm, it has to be shown that there was a specific underlying traumatic event that was unexpected for a firefighter or police officer to encounter within the scope and course of work. And the reason for that limitation is otherwise, without that kind of a limitation, every firefighter, every police officer, by definition, they respond to events that can be traumatic. And so every firefighter, every police officer could potentially be entitled to benefits for PTSD just by the virtue of doing their job, and the fund can't afford to pay that. So,
my question to you on that issue is, but if we hold in your favor on that issue, isn't the opposite true then? That you can never have a firefighter or an EMT have a successful PTSD mental disability claim, because all of this tragedy is expected? That's
a great question, Your Honor, but the answer, I think, is no. And we cite a case that's an example. It's from New Jersey. It's the Russo case that's in our briefs. One thing I'd like to point out that's very important here is the standard for recovering PTSD benefits here is essentially identical to the standard that New Jersey applies by common law. And I have not found that standard elsewhere, so it seems that this standard for Chattanooga was probably influenced by the New Jersey standard. And what you will find with the New Jersey cases is there's multiple cases where PTSD benefits are awarded, applying this exact same standard. And the Russo case provides an example, right? And what we're arguing is you don't just look at the subjective expectations of the firefighter or police officer. You look objectively at training, job experience, job description to determine whether it's unexpected. In Russo, you had a first-year police officer not trained to fight fires, was called and responded to a house fire. There were people trapped inside the house. The officer's supervisor ordered him to go in the house and get the people out. He went in the house and he brought 2 people out from the first floor. There was a third person on the second floor of the house that was at a window crying out for help. The officer went inside. The fire was too hot for him to go up the stairs. It was singeing his uniform trying to go up the stairs. He came back down. The person on the second floor died. Firefighters arrived, brought him out. The body was placed in the lawn, and the family members of the deceased person confronted the police officer, yelling at him, blaming him for the death of this person. And the New Jersey Supreme Court said, you know what? That was unexpected. And they awarded benefits because it wasn't what his job description as a police officer didn't entail responding to fires. He wasn't trained to respond to fires. His work experience didn't involve responding to fires. And then we also cite the Mount case from New Jersey, and it addresses two separate disputes there, one in which it denied benefits, the other in which it granted benefits. So to your question, Your Honor, Davis, no. Accepting the interpretation advocated by the board would not mean that no one ever gets benefits.
So what the court has to look at, though, really is sort of the specific facts of each particular case and determine whether those facts, given the particular claimant's job, whether it was expected. So it's a fact determinative inquiry. And in this case, the judge said, you know, the specific, like, this was not just I responded to a fire and some people were injured. He pointed out, or she, I can't remember who the trial judge was, but that, you know, we had pretty grotesque injuries, skin sloughing off, and then we had sort of an interesting twist with that where we had the person that he saved, the child came back a few years later and was extremely disfigured, and it made him wonder, did he do the right thing by even saving the child given the extent of his injuries? That and a couple other things that kind of all combined. Why can the trial court in this case not look at those particular facts and say, you know what, given this, the specific nature of what he experienced, I think that does fall within the unexpected language. Right, I
think you mean the board.
Yes.
The board denied. Yes.
Board. Thank you.
Yes. So the position of the board has been that, you know, firefighter Long went through level 1 and level 2 firefighter training academy. He was certified as an emergency medical technician, EMT, was certified to respond to hazardous material spills. By experience, he'd been on the force for 15 years. You know, it was common to respond to car wrecks. That was just part of what they did on a routine basis, the firefighters. It's common for firefighters, you know, to respond to house fires where people get burned. I mean, that's exactly what they're trained for. And I'll point out that in his brief, Long admits on page 25 that he agrees, I'm quoting from the brief, he agrees that responding to those types of calls was expected in his role as a firefighter, and he received training to be able to respond to those events. The question here is very narrow. Is the trial court said, look, any traumatic event by definition is unexpected. If it involves trauma, no one could ever expect it. In other words, the trial court's position was, unless you knew exactly what was going to happen on this day, at this time, at this place, it's unexpected, just because it's traumatic. And the board's position is, you know, that's just purely subjective. I mean, that means that it's, you know, Judge Davis, you know, you said, well, under the board's standard, you know, you could never recover for PTSD. We disagree. Well, under the trial court standard, you'd always recover for PTSD. Everything's always unexpected.
If you could prove that you suffered PTSD related to those incidents.
That's right. And there's no debate here that he was diagnosed with that. Mm-hmm. The question really...
Let me go back. So your argument that they would always qualify, no, they would only qualify if they proved PTSD as a result of these...
That's right, Your Honor. I'm talking just about the unexpected piece of it. That's the only thing we're really disputing here, is how do you go about applying the unexpected requirement? And as we point out in our brief, okay, in the workers' comp context, for example, in Tennessee, to recover for an injury, it has to happen in the scope and course of work, and it includes mental injuries. And the Tennessee Supreme Court has said, well, if somebody can recover for PTSD just by doing their job, that's unlimited liability. Okay, that's too broad. And it said, for it to arise out of the scope and course of work, a mental injury has to be unexpected, extraordinary, unusual, right? And that's the same kind of standard that the board is advocating here. And it's the difference between what the trial court ruled is the trial court said, look, it's always unexpected if it's traumatic. What we're saying is, look, you need to look at job description, training, experience, all the facts and circumstances to determine whether it's unexpected or not. I think with that, I think the events here were exactly the kind of events that Firefighter Long was trained to respond to. And as a matter of policy, limits have to be placed on PTSD recovery, solely mental harm recovery, because if the ability to get those benefits were too easy, it would really, it's hard to substantiate. And so it's a policy limit. Thank you.
You have your time for rebuttal. Thank you. Hear from the appellee.
May it please the court, my name is Janie Parks Varnell from Hamilton County, here with my colleague Logan Davis on behalf of the appellee Matthew Long. This court should affirm the decision of the lower court for 4 reasons. The first was touched on by my opposing counsel in that this court and the Chancery Court do in fact possess subject matter jurisdiction to decide this case, because the Uniform Administrative Procedures Act, or the UAPA as I will refer to it, does not apply to decisions by the Chattanooga Fire and Police Pension Fund. At least their contested case procedures do not. Second, the trial court was correct when it held that Matthew Long met the fund's requirement for proving PTSD that was a result of unexpected and undesigned events that occurred while on duty. Third, it was correct when it held that Matthew Long was permanently and totally disabled, therefore prohibiting him from returning to work as a firefighter in the future. And lastly, the trial court was correct when it denied the fund's motion to alter or amend. Touching on subject matter jurisdiction, I rarely find myself in a place where I've raised an issue in a responsive brief and then had opposing counsel agree with me on it. However, I will say for the court's benefit...
Just accept it.
Yeah,
Yes.
I would just move on.
Just accept it and go
Excellent. Then I will do that. Thank you. Moving to the second part of my argument with the undesigned and unexpected language. While the fund has argued here today and in their briefing that the lower court employed a purely subjective standard, that's actually inaccurate. What the lower court did was exactly what the fund has asked it to do and has argued about today. The lower court examined Matthew Long's training. There was evidence in the record that it considered about the specific training he received on how to respond to events like this. He documented in the pension fund hearing that while he did watch videos in the academy of injuries and burns and things that could happen while on duty, it wasn't anything so bad that you couldn't show your kids, I think was the specific quote that Mr. Long said in the hearing. The trial court considered that and considered that appropriately. The trial court also considered Mr. Long's specific experience in the jobs that he's had. The trial court looked, as it should, at the specific events themselves. Judge Davis, you mentioned it a second ago. One of them involved a pretty severe injuries of children with skin sloughing off, having to perform CPR on an infant with a crushed skull, and then the very unique trauma-inducing experience of having a severely disfigured boy come back and thank Mr. Long for saving him, and the guilt that that brought up. The medical records, which the trial court correctly considered, address over thousands of pages that in every single EMDR or cognitive processing therapy that Mr. Long endured following that specific event, he always brought up having to see that young boy and having the guilt associated with saving him and how his quality of life was so diminished. That is what the trial court considered to be events that were unexpected, that no amount of training could have prepared him for.
How was it unexpected?
It's unexpected almost in the very specific ways that each one of these events can affect the first responders that respond to them. I mean, you can have any house fire or any motor vehicle accident, but there was something about these specific events that...
What?
Why?
What was unexpected about first for the car crash? It was a horrible, horrible crash. And
I think with the car crash...
and I'm not questioning whether or not right now the PTSD happened, but
Sure.
I'm questioning what was unexpected
I think
about
if you
having to deal with a horrendous car crash and horrendous injuries, including to children.
I think if there was a common denominator amongst all of these issues for Mr. Long and all of these incidents, it was the children. And I think with the car crash in particular, this was the first time I think he reported to his therapist seeing the car crash, seeing there was a mother that I believe was using a 24 case of beer as a armrest in the car, and seeing the amount of neglect that mother had for those children, didn't strap in the car seat at all, so it bounced around like a ping pong ball is how he described it. Then for him to perform CPR on that infant only for it to pass. Then describing the younger child who was ejected 10 or 12 feet from the car and the injuries there. I believe the particular issues with these specific events as reported to his therapist were what was unexpected in them was the amount of trauma that these children were having to endure by things that were outside of their control. He had a lot of survivor's guilt for the one individual that did survive and came back to thank him, so much so that when he was in inpatient therapy, they made him write letters to the people that he saved in order to process that. I think in particular to Mr. Long, these were unexpected events because of the unexpected response that he had to them, as well as the gruesome characteristics of each event itself.
All right, so it was his unexpected response that makes them unexpected.
I think that's part of it. I think the other part of it is the specific events themselves. And
okay, I'm still having difficulty. I want you to help me. Why? I mean, firefighters, have, I think, horrendously difficult jobs to do, as do other first responders. And they do jobs I couldn't begin to do. But responding to terrible car crashes involving children as well as adults, how can that be unexpected? I mean, that's what they do. One of the many wonderful things that they do.
I think what the fund is trying to do and how that is being applied here is that we have come to expect that just because they're trained to respond to these types of incidents, that being faced with the incidents in that moment cannot at all be unexpected. The things that they witness on a day-to-day basis, the particular events like these, where you're having to, I mean, I go back to the infant because that's what he talks about a lot in his therapy is he can go through as much training as he possibly can and still not expect to ever have to do CPR on an infant whose skull has been crushed, and for that CPR to not work and that infant to die right in front of him. I think what we're asking then, if this is how this standard is applied, is we're asking these officers and these firefighters to essentially respond as if they're robots and are incapable of experiencing mental health disorders as a result of the things that they've seen. And to touch back on Ms. Judge Davis's question to opposing counsel about, isn't the opposite true? I believe that it is. I believe that under the policy as they have had, as they are asking this court to enforce it, there is not a set of facts. Let's say it's a house fire or a car accident or an unresponsive party or anything at all that firefighters are trained to respond to. There is not a set of facts where a firefighter can be so traumatized by an event as to qualify under this plan, as they are asking for it to be enforced. The only example that they're able to provide this court was a police officer not trained in responding to fires that responded to a fire. But that police officer, let's say they worked for the city of Chattanooga and they were applying under the city of Chattanooga's pension plan, they would not qualify because in the pension plan, one of the other requirements is that the traumatic events occurred during and as a result of the applicant's regular or assigned duties. That police officer's regular or assigned duties is not to respond to fires. He just happened to be the first person on scene. So even in the example that they cite, that officer would not qualify under their own pension plan and under their own disability plan. So, going back to what the trial court did here, the trial court did in fact consider everything that it was supposed to consider. It considered the specific events, it considered Mr. Long's subjective response to those events, and then it considered the training and experience that he had. And its ruling here should absolutely be upheld. The fund also argues that the trial court should not have found that Mr. Long was permanently and totally disabled. I did want to touch on this because the trial court was right. There is absolutely nothing in the record that proves that Mr. Long's PTSD could probably be corrected. There's also nothing in the record to prove that he abandoned treatment. We have cited that in our responsive brief with specific cites to the record. Further, the only expert medical proof in the record that clearly provides that he is permanently and totally disabled is the report from Dr. Caruso, which remains unrefuted. In conclusion, because the trial court considered the appropriate standard here, found that these events were unexpected, and then considered it in both a subjective and an objective standard, as the pension fund even asks it to do, and because it found that the substantial and material evidence in the record was contrary to the fund's decision, that decision should be upheld. On behalf of Mr. Long, thank you very much.
Thank you. Hear from appellant rebuttal. Would you agree that under the fund's definition of unexpected, that for a firefighter, we'll say here in this case, to qualify is going for PTSD resulting from something that happens during his job or her job is going to be exceptionally rare?
I think it would be rare. It would be unusual. Yes, Your Honor. And that's exactly the point. That's exactly what that standard is intended to accomplish.
So you're saying the standard is intended to pretty much not cover PTSD,
No,
except in exceptional cases?
That's exactly right, Your Honor. And it's exactly the standard. And the reason for that, you know, the Fire and Police Pension Fund provides very generous benefits to firefighters and police officers who do essential important service for the public and often risking harm to themselves. And because of that, the Fire and Police Pension Fund provides pension benefits that are greater than what you might get in other contexts. But the fund has an obligation to ensure that it remains actuarially sound, that it can pay, that it has the money to pay for benefits. PTSD is, it's mental harm, and as we know from many contexts, mental harm is difficult to prove definitively, okay? It's hard to prove without a doubt. You can't X-ray mental harm. And for that reason, this policy puts limits on it. And you see the same kind of limits imposed by Tennessee courts in the workers' comp context, in the injured on duty context, and the cases we've cited. The fund made a policy decision.
The challenge, though, in this case is the exact verbiage used by the fund in this policy. If they had said reserved for exceptional cases, extraordinary cases, maybe it would be, I don't know, it might be easier to define and apply, but they use this word unexpected, and it's problematic, because I do think if you interpret it bright line either way, either your proposed bright line or their proposed bright line, you're resulting in all claims being accepted or no claims being accepted for traumatic stress injuries in these jobs where they're going to see traumatic things.
I disagree respectfully, Your Honor. I mean, here's a hypothetical. A firefighter responds to a house fire, goes inside to see if there's anybody in there, and a resident shoots him. That could happen. Is that expected? I mean, is that what a firefighter's trained for? Probably not.
Responding to crazy people?
Responding to gunfire. Maybe it's expected, maybe it's not. But all the board is advocating for is that the court should look at all circumstances, including job description, training, experience. Where the trial court got it wrong, right? On page 12 of its opinion, it's in volume 9, page 1338 of the record. It said the event, not the type of event, is what had to be unexpected. In other words, the trial court's putting an unattainable burden to prove that it's unexpected. Because he said you had to know this specific event was going to happen. That, in effect, disregards training, experience, job description, all the other stuff. In effect, you're basically saying all traumatic events are, by definition, unexpected. All we're asking the court to do is look at all the facts and circumstances, right? And we'd ask you to reverse the trial court.
Thank you.
Thank you.
Court thanks counsel for both sides. We appreciate your arguments today and your briefs on this.